With the permission of our learned director, Mr. N.G. Sherpa, I would like to begin today's session on law of bail and disposal of criminal cases by resorting to the triple method of plea bargaining, compounding of offences, and Probation of Offenders Act 1958. On behalf of Sikkim Judicial Academy, I take the privilege to extend a warm welcome to all the esteemed guests who are present with us today, be it physically or virtually. I wish you a pleasant morning and a fruitful day ahead. Today is a momentous day, for we have with us Honorable Mr. Justice Ashim Kumar Roy, former Judge, High Court of Calcutta. I request our learned director to kindly welcome His Lordship by offering a bouquet and a memento as a token of our appreciation and respect.
Has started.
Consequently, I would also like to request our learned director to read the profile of our honorable resource person.
I believe that I am audible. No? So, thank you, Mr. Sherpa. And before I start, I want to get myself introduced with all of you, with Learned Judicial Officers present. So, one by one, you are Mr. Who will introduce me?
Principal District Section Judge.
Yes.
Yes.
You are District Judge?
Ashim?
No, this is, yes.
I am Jalatai, District Session Judge, Special Division 1 Gangtok.
District Judge, which...
Special Division 1 Gangtok.
Okay. So, you? Okay, thank you.
Good morning, Lordship. I am Jivan Kharta, District and Session Judge, Special Division 2, posted at Gangtok.
Good morning, Lordship. This is Samita Sharma, District and Session Judge at Namchi.
Good morning, Lordship. I'm Mahima Rai, Civil Judge, Judicial Magistrate, Rongi.
Chief Judicial Magistrate.
No, Civil Judge, Judicial
Judge?
Magistrate.
Yes.
Good morning, Lordship. I am Sesihan Limbu, Civil Judge cum Judicial Magistrate, Yangang, Namchi District.
Good morning, Lordship. I am Nairitya Sharma and I am Civil Judge cum Judicial Magistrate, Rampur.
Good morning, Lordship. I am Samia Children, Judicial Magistrate, Yakka.
Good morning, Lordship. My name is Jwala Thapa. I am Chief Judicial Magistrate, Yalsi and Soni.
Chief Judicial Magistrate.
Good morning, Lordship. This is Adipika Chetri. I am a CGM from South District.
Chief Judicial
Good morning, Lordship. This is Sonam Denka Wongdi. I am the District and Sessions Judge, Mangam District.
Magistrate.
Thank you, Lordship.
We have a judicial officer attending through virtual mode also.
Okay.
Judicial officer.
Acha, acha.
They can also introduce.
Good morning, Lordship. I'm Johnny Sherpa. I'm posted as Civil Judge and Judicial Magistrate at the City Council.
Yes,
Good morning, Lordship. I'm Ruby Rai and I'm posted as Civil Judicial Magistrate, Jason Subdivision, South District.
Thank you. So, where is the program chart? So, what I am suggesting, subject to your convenience, that I will deliberate on law of bail at the end. let me start with the other things. That is very vital at the present moment because there is a direction from the Supreme Court to not only, it is not that to train you, but to apprise you, or in other words, to sensitize you about what Supreme Court is saying about the three-stage method. So as to resorting of three-stage methods for reducing the huge pendency of the criminal cases all over the country. This is not for Sikkim. I do not know here how many criminal cases are pending in the trial court. Can you give me the number? Okay. So, how many number you are facing in every day? How many criminal cases are started? The Chief Judicial Magistrate can tell me that the complaint or the cases are coming to the notice. Do you have any idea? Or you are not giving any? Because, okay. What I am saying, that very good. I believe that all of you have understood what the Supreme Court has said in these decisions, where one of the practicing lawyer and a whistleblower who has Mr. Gaurav Agarwal, who approached the Supreme Court in regards to the policy of strategies in disposal of or grant of bail. But if you go, in this case at least, Supreme Court has not spoken anything about this particular direction. Here, on the other hand, Supreme Court has suggested that the triple method, that how this pending criminal cases to be disposed of. Because all you know that the criminal justice delivery system, not only criminal justice delivery system, all over the country, the huge number of cases are pending. So far as criminal cases are concerned, there is jail overcrowded, delay, and then they are saying that delay means that our justice is denied. These are the few things people are saying, and losing faith on the judiciary. They are saying for a long time they have to wait when the case will be disposed of. These are the few very important things which now troubling the entire judicial fraternity of our country. So, first, what are the triple method? First of all is, they suggested one is for disposal is plea bargaining. Next is compounding, and third is Probation of Offenders Act. Now, what I understand, these are the things. The Supreme Court said that in every district, one judicial magistrate of first class, one chief judicial magistrate or additional chief judicial magistrate, and one session judge has to be identified. And the learned judicial officers to be entrusted to to identify and then to entrust him to take steps for disposal of these cases. So then what is to be identified? First of all, the Supreme Court has said for selection of the court in this year. Then it says that identification. Identification, what identification? Identification of cases which are pending for trial or charge has been framed and the stage of evidence, but not yet disposed of. Then this is one thing. Another thing, what actually you have to identify? The accused has already charge seated, and as I said, that evidence is going on. But remember it that the offences for which he has been charged or charge seated must not exceed with a punishment more than 7 years. Right? Apart from that, you have to, this exclusion is very important. This exclusion is, another thing is that notified offences. Are you aware of the notified offences? Not aware. So this is, if you have the book with you, CRPC, so you find out in this chapter of plea bargaining, 265A, I believe that there will you get a list of the, this is a new chapter of plea bargaining, just after 265A. Have you seen, every one of you got it? As you know, this plea bargaining, concept of plea bargaining, we have borrowed from the US, American concept. And first 142nd Law Commission, then other 155 Law Commission, then 172 Law Commission, all 72nd Law Commission, all suggested for introduction of plea bargaining. In the meanwhile, after the Malimat Committee's report that reforming the commission for this committee for reformation of criminal law, they also suggested for plea bargaining. Then this provisions has been introduced. In 2003, the bill was passed in the parliament, and in 2006, this has been enacted and brought in the statutes. Now, one of these things that you have to, one has to exclude the notified offences, that the or dowry prohibition, Commission of Soti Prevention Act, indecent representation, all the cases relating to the women and the other, and this is social aspect, and other economic offences. Right? Now, then again, the offences against the woman and the child less than 14 years has to be excluded. And another very important thing is this: the person whose case you have taken up for consideration must be the first time offender. So now you tell me, what do you understand about the offence against women? Please tell me. You tell me. Offence against, what do you understand about the concept of offence against women?
Offences like under section 376.
No, that we know, that in the Indian Penal Code, you just come to this speaker, otherwise everybody will not hear what you are saying. So I am trying to understand from you your idea about the offence against women.
That's protection of women from domestic violence act. Nowadays, it is not only the physical hurt or this thing, but it includes mental abuse, economic abuse.
So you are, according to you, that where the woman is the victim, that can be said that this is an offence against women. What is your views? Same view. Okay. So, in a case, a woman, a lady, someone X was standing in the bus stand. Somebody from behind came and snatched his chain. So it is an offence against women. Tell me. Yes, tell me.
It would be a case of theft, Lordship. So of course it involves a woman, but not necessarily it should come under this, Lordship. One of the notified offences.
No, not only notified offences. You just remember, Supreme Court in this suggestion excluded those cases which involves an offence against woman, and then the offence against a child who is below the age of 14 years. Right? Therefore, I am asking you and I am trying to understand from you. Here I tell you one thing. I am not here to teach you anything, but to show you the way how to learn and share my experience and what I have gathered in, because you are the learned judges. You are sitting judges. What you will do finally, that depends on you and on your judicial discretion. I can only give you the example and instance of the cases which you will keep in mind, so that in future, in your decision making process, it will assist you. So therefore, one must first understand what is the offence against women. You tell me.
Lordship, the example that you gave, even though I think it is the offences against the property, because it's a theft and it's not offences against the body. Broad category of offences against.
You are saying about body. Very well. So you are in the street, you are just crossing the road. One car suddenly with a rash and negligence came and pushed you and knocked you. This is an offence against women. Yes, madam. Tell me whether this is an offence against women or not.
Lordship, I think it would include offences, sexual offences against women.
This is?
It would include offences of sexual nature, like rape and all, and also harassment and sexual harassment.
What do you say?
Lordship, the example which Lordship gave right now, I think it will fall under MSCT cases.
It is for?
It will fall under motor vehicle cases.
No,
The example which
no,
Lordship
this is
gave
an
right
offence
now.
under 304A.
The
If
example
a
which you gave.
car knocked you down and killed, this is a rash and negligent act.
Yes.
And if it is only cause some injury, then that is a 338 IPC. So therefore, you cannot say this is an only offence against motor vehicles act. It is both, because after you have some accident has caused someone's death, then
But then Lordship,
that
it's not
he should be
against-
tried under the Indian Penal Code.
Yes.
Then the coming question is what should be the compensation for loss of life or for suffering injuries. So therefore, you have given your views. What I find that the woman, merely because woman is a victim, that doesn't mean that this is a case against woman. So when suppose I have something, as you said, that's it is a case of theft. Some dacoity is committed inside house, so where the woman was tied up and her ornaments were looted away. These cases cannot be the offence against women. These are the offence is of kind of gender neutral. But because this can also be happen against a male, it can also be against a female. But the offences which cannot be committed against a male person, this is a gender specified offence. That the sexual harassment or domestic violence, these are the cases, and some offences relating to the marriage. These are essentially the offences against the woman. Am I clear or not?
Yes.
Clear? So, therefore, when you will try to find out, you have to find out what are the offences, because you have to exclude them. And this is also reduce your burden, because you have huge cases. You have been busy with the disposal. Now everybody is busy with disposal because some points or other things are getting. But thing is this, that you have to be very careful about how to be excluded. Don't take wrongly, no matters be taken up. And then a offence against a child who is below the age of 14 years. And one thing you tell me, that one lady has been kidnapped, who might be aged about 20 years. So that is also against the offence against women, because not only the victim, because for some illicit purposes that she should be taken to somewhere and be abused. So these are the offences against women. Now, and you have also come by now have seen what are the notified offences, and these are the things. Then one is very important thing, that after the judges are selected, I think that let us take up this case, that all judges have been selected, who will be in charge of this to resort the triple method for reducing the criminal cases. Now his duties is to identify cases. By now we have identified those cases. Then next step is to issue notice. That is very vital. The notice whom you have to issue. See one thing, that I have said already the charge sheet has been submitted. Let us taken up from for the priming that the trial has not been commenced. Charge sheet submitted by the police. So far as a case of complaint is concerned, where court take cognizance under 190, what should be the proper stage? Am I clear? I am saying, so far as a criminal case arising out of a first information report, right? So it is ended on charge sheet. So this thing now court has taken the as you know what is taking of cognizance. Cognizance is the taking the judicial notice to proceed further to bring the accused before the trial court and to certain proceedings. So therefore it is one part investigated by the police. What are the other cases and what stage you will take the other matters? Those are the cases where suppose you have filed a complaint under 190. Court take it is a private complaint. On that court take cognizances. Deposition of the witnesses were recorded. Or some inquiry under 202 is done. Instead of dismissing it under section 203, the summons have been issued under 204. Right? So when summons is issued, then these are the cases you can take for consideration. So where charge sheet is submitted, where 204 summons have been issued, and after if you know that after 204 summons case is found to be exclusively sessions travel, the magistrate taking cognizance has to commit it, like these police cases where charge sheet has been submitted. Right? Now the notice part, that is what I am saying, it is very important, because it is in consonance with the principle of natural justice. And it is, if I say otherwise, it is a matter of informed consent. Are you aware of this concept of informed consent? Normally this practice is prevalent in the medical line. The doctor, before undertaking a surgery or treatment of a patient, he should apprise the patient what are the nature of the disease, what are the treatments available, and what would be the prognosis, and what would be the consequences, and what would be the cost. Then patient agreed that this is the concept. From there we have borrowed it here to say that informed consent. Now, in the content of what should be the content of notice? In the guideline it is specified that the court must say in the notice that we are proposing to whom to notice has to be issued. First off to the accused, then to the, if their lawyers are there, to the lawyers, and then to the complainant. Same complainant and victim, as you said, that who lost the complaint, or the who suffered, that you know that now after the amendment of CRPC 2W, that you will find who is the victim. Suppose the man is, that case will not come. Suppose after the incident happened, the man, this complainant, the victim has expired, actual victim. So his legal or her legal heirs would be the victim, will come within the definition of victim. So therefore, you have to send a notice to them, proposing that the court is considering the question of disposal of the case by resorting to triple method, that by plea bargaining or by compounding and then by probation of offender, and take their views. Similarly, the complainant also to be given notice. He will come, he will apprise that we are going to do this. Then you have to take their consent. After, you have to, at that stage, you have to apprise them and sensitize them what you are going to do. Because he is maybe that he is not aware, maybe highly educated but don't aware about this legal concept. So you have to make them understood that what are the things, what will be the consequences. After doing that, you have to give them some time for reflection. Suppose any one of you have recorded any 164 statement of an accused? Have you recorded? Any one of you? Not the statement of witnesses, but the confession of an accused. Have you recorded? Normally the judicial magistrate are supposed to record. Suppose somebody committed crime, said that I will confess, I will make a judicial confession. So none of you. So that is there, when a judicial confession is to be recorded, there are some statutory warning to be given. That if you make this confession, you will not be, first of all, you have to ascertain the voluntariness, that he is volunteer. No, it is, you have to ask him that whether anybody has give you the assurance that if you make this confession, that they will not to be suffered any criminal consequences, or you will be paid something, or you will be otherwise be obliged. So, and then also said that had the police told you that if you confess, then no action will be taken. I am a magistrate, I am ensuring you that if you don't make confession, I will not send you back to the police custody, you will be sent to the judicial custody. You will be safe, and all these things. This is the time, and give some time, 1 day or 2 days, for his reflection. So here also, after apprising the complainant, victim, accused, everybody, you have to give them some time. Maybe 10 days time or 1 week time. Go, think over it and come back on the next day and fix it. So content of the notice is very important. That on the date they appeared before you, you have to let them know that what is the provisions of plea bargaining and other things. Then what is the benefit? Mostly the accused has to be understood what is the benefit. Why he will come for plea bargaining? Why he will come? What benefit he will get in compounding the offence? Where benefit will he get if this case he is released on Probation of Offenders Act? This you have to very clearly apprise them. The judge will be selected for this purpose. Next is this is a case I have given you, that though where the accused are on bail, but say, let us take as for example that accused is in judicial custody. What procedure you have to adopt in those cases? He is in jail custody. So either he will be brought, as you know, what is the remand period? For how long you can remand the accused in custody? 14 days. On the 15th day, they will assist 14 days, 2 weeks. So, on the remand date, he will be brought. On that day, you have to take the chance of telling him. Right? If on that day, he has to be physically produced before you. And otherwise, if it is that already in jail custody, trial is going on, it may not necessary to on every 14 days. Yes. In case of you are holding the trials, right? So, in holding trials, if you every 14 days the accuser produced before you,
Yes.
or not?
Yes.
Yes.
In trial also?
Yes.
Yes,
Yes.
Or on the date fixed?
Trial also.
Trial also.
During the
Remand,
trial,
every 14
days
days,
you
remand will be taken.
You take
Lordship, both actually.
Huh?
Lordship, actually, if I may just inform your Lordship, now we specifically have remand advocates appointed for most of the under trial prisoners by the Sikkim State Legal Services Authorities. So a duty is cast on the remand advocates to move for bail. And also the District Legal Services Authorities also, we have these UTRC committees. So they can recommend from time to time, they can identify under trials and recommend their release on bail to the
No,
custody.
I am not talking about that.
Lordship, it's
That
like
is one part. What I am asking you, that in a case where the investigation is not over, charge sheet is not submitted, you are...
Then mandatorily they are released on bail.
No. I am asking you that about the question of remanding. An accused is produced before you. You are a magistrate. Maybe police arrested somebody and produced you before you. So, what should be, for how many days you can send the accused in jail for remand?
14.
Charge sheet now submitted. Case has been committed to the Court of Sessions. So, while during the period of charge sheet, you are exercising power. Where from you are getting? What is the source of power? What is the provisions? Under which provisions you are sending him? Under which authority you are sending him to the judicial custody for 14 days?
Lordship, this after filing charge sheet, session trial 309.
No. 309 is latter one. But during the investigation period.
167.
Right.
167.
Very right. That is under 167. And as he said, that after it is committed, this is under 309. So in case of 309, in case of 167, you are sending him, remanding him to the custody for 14 days. And in case of 309, the charge is framed. Now the date for evidence has been fixed. You have prepared a schedule, right? That these are the dates. Although it is 309 said that it should be done on a regular basis and day after day. But sometimes, always it is not possible. So I have to give a 2 months, 3 months date after date. So that is what I find in Bengal. But I do not know what happens in Sikkim, because there we are overburdened with the criminal cases. So in those cases, what you are doing? How many days for sending the accused to remand?
Lordship, what I do is the remand is done as per the section 167 every 14 days. But even if the date is fixed for after a month, but we ensure that the remand is done within 14 days period.
Very good. So you have get an opportunity after 14 days, whether it is fixed for trial or not, the accused to be produced before you. On that day, you take the chance of apprising. If you find that these are the offences not exceeding 7 years, not notified offence, not offence against women, and not against a child below the age of 14. So therefore you take advantage of that situation and apprise them. And in case if the accused is not produced, so you will request his lawyer to do the needful, or you will, as now it is said Supreme Court, that the DLSA, the District Legal Service Authority, has to select some senior most lawyer who has sufficient practice in this line to go to the jail and to apprise the accused about all these things. So these are the procedures. Then these are the things. And so far as the suggestion for, I am not on that issue, I am not telling you anything about the provisions of the bail. Recently the Chief Justice, you have seen the comments of the Chief Justice. What Justice Dr. Chandrachud said about the bail. What he said?
He said that the subordinate courts are under pressure, so they are afraid to release people.
Right. That is what he
Out
said.
of fear, he used the word. Yes.
They are appealing that the higher court, what the higher court will say. So they are saying. Because concept is changing. Sometimes one judge is saying, one honorable judge is saying this. So these are the essential things. So 3 procedure has been prescribed. One is plea bargaining, one is compounding offence, and another is this probation of offenders. Now let me take this chance to tell you few words about the plea bargaining. Already I have told you that the three methods you have to take for this. So let us first come to what is plea bargaining. Okay. This is what you know. So you please come to the chapter of plea bargaining. This is a new chapter, 21A. This has been brought in the statute book, as I told you, in 2006, after following the recommendation of law commissions and the recommendation of Hon'ble Justice Malimat, that is Malimat Committee, that Committee for Reform of Criminal Law. So, plea bargaining. I have some doubt how far you will be successful to convince an accused to opt for plea bargaining. Because plea bargaining is a concept, as I said, that we have borrowed from the USA. This is a negotiation of a trial. That what you see if you go through the one after another, that the guidelines prescribe that in case of plea bargaining, you have to bring the accused and the complainant with them. You have to apprise them that in case of plea bargaining, one of the basic and essential element is this, that it voluntary test. You have to satisfy it. You have to record your satisfaction that the accused is volunteered. I have apprised him clearly what are the pros and cons of the pre-bargaining, and he have understood everything. Now he is agreed. So, because you have to first of all you say that if you entered into plea bargaining means that you have to negotiation between the accused and the prosecution, and where the cases are not punishable with more than 7 years, not against women, not against a child of 14 years, and then the other things what you said, that notified officers. So means you have to pick up those cases. So you have to that here you cannot if you pre-bargaining, it is something. It is you have to first record a conviction. Without recording conviction, can you enter into plea bargaining? Because the first condition is this: accused has to admit his guilt. That you know that what is plea, that at the stage of framing charge, after framing charge, you have to say that plead guilty or not. That this is the charge against you. Do you plead guilty or not? If you said that yes, I am pleading guilty, so you can convict or acquit anywhere. But The time again Supreme Court has said, merely because the accused has only pleaded that I am guilty, that is not enough. Maybe that you may say the question that the one hurdle is there, that no person shall be deprived of his life and liberty except according to the procedure established by the law. What Article 21 of the Constitution says. But then you can argue, yes, under these provisions, there are provisions to plead guilty and then you can convict or acquit, whatever it may. Why not? I will convict. This is a procedure established by the law. But then again Supreme Court went further and said, no, this is not proper. You hold the trial. In my experience, I find when I was an advocate, one case. So what happened? That one lady and his husband of his elder daughter, sister-in-law had some bad, not a good moral. So one day her husband, previously he was trying to disturb her. One day her husband was not there, that time he came and then doing something mischievous. So the husband that time, all of a sudden, the husband arrived and he found everything that he is disturbing his wife. He killed the brother-in-law of the wife. Now, what is it? But the wife what did? He instead of killed by the husband, but he went to the police and confessed that it is I, to somebody may be advised in right up by defense, I have killed him. And as you know, under the Indian Penal Code, there is also limitation of exercising right of defense. If I in bare hand give you 2 slaps, you cannot brought out your firearms and fired a shot at me. Then you exceeding your right of private defense. You will not come within the exception, you will be tried regularly. Similarly, in that case, court hold that even if that is done, that she has exceeded her defense and she was finally convicted. Therefore, those are the things, because in that case what trial judge committed error, he on that plea of guilty convicted her. So we took the advantage of that and argued before the court that that was not rightly done. So case was again remanded back to the court. Has to be satisfied before holding a person guilty that there are sufficient materials, abundant materials, so for which that the person can be convicted. Now what happened? So therefore, if you first of all in the plea bargaining, it is a settlement by negotiation. So he will has to suffer, and you come to that to 265B, how the cases to be disposed. Just you see, just you take some time and look at it. If court is unable to release the accused on probation of offenders act, then what happens? Subsection D will attract. May I now proceed? So, you see that the punishment you have to impose, if there is a minimum punishment prescribed, in some cases you will say that this is the sentence and this is the minimum sentence. In those cases, you have to impose the sentence of half of the if sentence. You tell me one case where maximum punishment is 7 years, but there has been prescribed a minimum punishment. What is this? Okay, so you have served him. This you take it, I have not taken it. What? Okay. So, serve. Have you taken the tea? Minimum sentence has been prescribed. So according to 265E, which clause is attracted in this case? C. So you can only give him half of the punishment, 1.5 years. Suppose, and in case where the no minimum sentence is prescribed, there D. 1. Now tell me one thing, listen everybody, that in case of 379 IPC, what is the sentence? 379. So it may be extended up to 3 years possibly. You don't have the IPC with you.
3 years of fine.
So this is the case. So you tell me one after another that the what in this case what should be the 1/4. Because in a 379, please listen, in a case of 379, it may be extended up to 3 years. Therefore, you can give him a sentence of 1 year, you can give him a sentence of 6 months, you can give that a sentence of 1 day only.
Actually, in the case of 379, then we use the probation of offenders.
Yes. Yes, that's right.
So we use A and A or B.
A, right, the court shall award the compensation to the victim in accordance with the disposition under section 265D and here the parties on the quantum of punishment, releasing the accused on provision of good conduct after admonition under section 360 or dealing with the accused under the provisions of the Probation of Offenders or any. Release the accused on probation of offender. So you are correct. So have you take your keys first. And the so what do you find that from C and D?
So we reduce it by half under C logic and under D 1/4. 1/4. And under 65(1) we can set off. Like I, we can set off under section 1.
Yes, but that is you are saying in respect of cases under A. 265 EA. right? And that is admonition, you can,
After admission.
and B, under probation of, both under probation of. And in case of D, where minimum, in case of minimum sentence, half. And in case of that, where it is not minimum sentence is prescribed, 1/4. So, please. No, this is sufficient. Let it be. Thank you. Yes. Now let us start, okay? So by now we have at least apprised of this provision of plea bargain. Now let me come to Probation of Offenders Act. So you kindly tell me what are the essential elements for adopting the Probation of Offender Act 3, 4. So as you said just now, very rightly pointed out that in case of 379, that section 3 will attract 380, 381, 404 and 420. Or any offence with imprisonment not more than 2 years. Yes, kindly tell me what are the offences you find that where punishment is not more than 2 years. You. Just give me example of few cases where punishment do not stay.
Lordship, under section 353, the punishment prescribed is imprisonment for 2 years or fine or both.
Okay. Any other?
Wrongful restraint.
Wrongful restraint. And what is the punishment of wrongful confinement? Just near to restraint, above. No, 279 we have already said it was this, as he rightly pointed out, that section 3 of the Probation of Offenders Act will attract. And in this case you can opt for admonition. Without executing the bond, he will be released.
Wrongful confinement extend to 1 year.
Huh?
Wrongful confinement punishment.
Yes, 1 year. Thank you.
Chapters 13, 14, these are all like.
Chapter CPC.
13, 14 is CPC. Logic.
1 minute.
Sorry, IPC logic. It's
I-
all punishable under less than 1 year, 6 months, 2 years. From section 264 to. Or from section 262 actually, IPC logic. From there on is 2 years, 1 year, 6 months, or only fine logic.
262.
From 261, 262 logic. 262 says 2 years or fine.
Using government stamp.
Yes, logic.
Going to have been
263A is
before use.
200 rupees fine.
Eraser of mark. prohibition of fictitious stabbing.
Up to 6 months and fine.
This all relates to use of counterfeit. And the offences of affecting the public health and safety.
I think magistrates might get cases like that, Lordship, for revived public weapons.
So what do you think about the Probation of Offender Act? But remember it, in all cases, this, if you follow this thing, this Probation of Offender Act, the stigma of conviction. What do you think? Because in plea bargaining, the question of, you tell me that in case of plea bargaining and Probation of Offender Act, when it comes into play?
Petty offences.
I'm not on
The stage, Lordship, stage.
that stage.
At the time of framing of charge.
After the conviction.
After the sentencing.
Yes, at the stage of sentencing. So that is why the stigma will be there, you are a thief. You are a thief. The people will say that you are not to be sent to jail, but the stigma will remain. So what do you think? If you convince the accused, they will agree, or they will, because everybody is thinking that I will get a clear acquittal. You will, if you find the mind of a criminal, you always think that after committing this, I will never be apprehended by the police. That is, with this approach, people are committing crime. That I will not be caught.
My personal experience, just to share with your Lordship,
Yes.
at the stage of framing of charge, sometimes when we explain to them that there is this option of plea bargaining and all that Lordship, sometimes they say, I plead guilty, but they will not incriminate themselves.
Oh, plead guilty, but merely pleading guilty
Yes,
will
sir.
not do.
It will not
It has
suffice.
to
Yes,
it has
sir.
to admit the guilt in terms of the offence.
Offense.
That I have committed this thing, is it not?
Yes, sir. Because they have to self-incriminate also.
So you have tried to apprise them about plea bargaining.
Always, we always inform them about.
Yes, what is your experience? Just take the mic. Mic.
Yes, Lord, sir.
Ah.
Similar proceeding were adopted.
So they are agreeable, or they are saying that no, I will not incriminate.
In rare cases, they will agree. In rare cases.
What?
In rare cases.
Oh, rare cases. Rare cases, they will admit the guilt.
Yes, sir.
So normally when they plead,
don't want to admit
they
they
don't, usually when they plead guilty, then plea of guilt is recorded.
No, but what he is pointing out, that they will say, yes, I am guilty. But that is not enough. You have to admit your guilt in terms of the offence. That yes, because you have to, the plea has to be recorded. But there are many cases that where this thing, plea taken was set aside because the learned court has not recorded plea in accordance with the law, in terms of the offence committed.
So we don't consider that plea of guilt at all.
What?
So when they just say I plead guilty, but they do not self-incriminate in terms of the judge's plain Lordship, then we
You
don't
proceed with
consider-
the trial.
Yes, we proceed
Very
with the
rightly done. Done very rightly. All of you
Yes.
doing the same practice, though. very well. And therefore, the stage of probation of offender applying and the stage of plea bargaining will come only after they admit the guilt and at the point of sentencing, not before that. So, can you tell me what is the difference between compounding of the offence, plea bargaining and Probation of Offender Act?
I think the magistrates might want to answer.
Lordship, in case of compounding, it is equivalent to acquittal.
Right. So, therefore, there will be no stigma. Achha, can you not compound an offence at the stage of the trial? If the offence is compoundable. But any offence you find that which is compoundable and not sessions travel, most of the, what is your findings? That the offences are compoundable, 320, 321 and 322, but none of these offences is station travel. You have to tell. Yes.
Sorry, what was it?
I am saying that 320 provides for compounding of the offence. Just find out. You also, okay? You also. Listen what I am saying. So, in table 1, some offences has been specified. In table 2, the table 1, it can be compounded between the parties. And table 2 with the leave of the court. Right? Now you tell me that any one of offence in either table are exclusively sessions travel. Whether any offence is there. You find any offence which is exclusively sessions travel? No sessions travel cases. Yes, what is your views? Any sessions travel case is compoundable? Why I am asking? Because she said that, madam, you said that when I ask you that about the compounding, you said that they will say, who are sitting behind you, right? So you have no role to play in 320? Have you any role? Huh? No. Suppose she has convicted someone in a magistrate tribunal case and case went up in that order of conviction is challenged and you are in the midst of the hearing of the appeal. So at that stage offence can be compounded or not?
Yes, sir. If it is compounded.
Right. Till up to the Supreme Court this case can be compounded. If you satisfied that there is no malice or malafide behind the compounding, then you can allow. So therefore you have also a role. And one advantage is this, that so far as 320 is concerned, the accused is get the benefit of an acquittal. So there will be no stigma. And you see possibilities in CRPC where there will be no disqualification. It is one thing of no stigma, acquittal, and another is disqualification.
Lordship, in section 320, clause 6, it says, High Court or the Court of Session, acting in exercise of its power of revision under section 401, may allow any person to compound any offence which such person is competent to compound under this section.
No, that answer we got, you have studied. I am saying that in some time the cases will amount, if you that 320 compounded, then there will be a clear acquittal. But in some cases there will be no disqualification.
Clause 8 says it amount to acquittal.
No, amount to acquittal, I am not asking you anything. I am asking you you are looking in which law? Now please look at Probation of Offenders Act. Then it will not attach any disqualification. Section 12. So what do you understand by the word disqualification? Hmm?
They should not be stigmatized in any way.
It will not be?
Stigmatized in any way. It should not affect his future prospects.
Yes. Mostly future employment.
Shall not suffer disqualification.
Suppose he is a government employee. So if he is convicted for a criminal offence, there is chances of taking disciplinary actions. So he will be disqualified, no? But if it is Probation of Offenders Act, he will get that disadvantage, which is not there in plea bargaining. Is it there in plea bargaining? So this is an advantage in Probation of Offenders Act.
But the advantage in plea bargaining is that it is not appealable also, the order passed under that provision. One cannot appeal against an order where conviction has been based on plea bargaining.
But in case of compounding,
You can appeal.
why?
Because it's with the permission of the court, Lordship.
No, because it amounts to an acquittal.
Acquittal. And there's
So
a specific bar.
against an acquittal, you can very well go for in an appeal, challenging the order of acquittal. But you correctly said that in case of plea bargaining, that is not an appealable order.
Lordship, section 13 of the Probation Act says.
Oh, section provision of 13.
Appointment of probation officer.
I will come to that. Where is your director? He sent me some questions. So some queries. I asked him repeatedly, why you have not sent? You were not asked.
Lordship, actually, I was really busy, so I could not prepare, Lordship. I was in the courtroom when I got the query.
So according to your views, what would be easier for you to convince out of this triple method, which is most easier for you to, which method if you apply, you can be able to dispose cases?
Compounding probation.
Compounding probation. And also, as he pointed out, that in in pre-bargaining also there is a scope of this Probation of Offenders Act. that you need not have to go separately. In case of 379, if you take the plea bargaining cases in 265D, na, what he felt? D.
A and B.
A and
A and
D.
B. B, B, A and B.
D.
A and B has this provision for probation of offenders.
E.
A and B.
E and
265B.
A আছে, should
A and B.
right.
But Lordship, here the problem is convincing the accused that it is beneficial for everyone. Because he's always scared of stigmatization and he does not want
About the counsel. So this is a little tougher for you to counsel.
So it a lot would depend on the skills of his advocate actually to convince his client voluntarily to
But you don't think that any role can be played by the court?
Yes, Lordship, courts can play, but they are I think they have lot of maybe in their own counsel also, Lordship.
Oh, they will never allow. Because if the case is closed, who will be the extreme sufferer?
Advocate.
So they will never allow.
Lordship,
Because
one
no
more
matter
thing,
what the
Lordship.
court says, they will always consult with the client, with the counsel, Lordship.
Okay. No, then naturally they will always.
Lordship,
And you have the highest.
Lordship, in India, if we see the conviction rate, Lordship, if we see the conviction rate, it's so minimal that an advocate will not take a chance to suggest his client to go for a plea bargaining in
So-
which, Lordship,
So if you say that in case of the Probation of Offenders Act, if somebody opt for Probation of Offenders Act and opt for plea bargaining, there will be conviction and the conviction rate will high. Is it not? So in that case, what the lawyer will do? That is another problem. And what is your, I call you because you send me that queries, I will give a reply to those things. Those are very important things. But before that, let me share with your experience about this thing. And next session I will on bail. Right, you tell me. But just now we have pointed out, please, what is your experience in this? You have shared, please all of you please share. So I will get experience with all these things. Because we never went to the trial court, I do not know what the problems the trial court judges and magistrates are facing. Here lawyers are shouting at the courts.
no, Lordship,
No, they are not misbehaved.
they don't
In
misbehave.
Bengal, in few courts, this is very terrible.
Here the decorum is very well maintained.
You see that collegium taken decisions. Yesterday also, 5 of the honorable judges from the different state has been transferred.
Yes,
One, do you know? One
yes,
from.
and Gujarat Bar is up in arms about it.
No, that was previously in case of 3 judges. Next, yesterday there was a collegium. And in that collegium, 5 judges have been transferred to different courts. And one lady judge who is in, she was elevated in sometime in 2013 December, he has been transferred to Calcutta High Court. But this Supreme Court is now looking after the transfer policy. Justice Chandrachud, after taking of charge, he first transferred 3 judges, now he has transferred 4 to 5 judges. But as you said that they went on strike.
Yes,
Why?
because they
No, they have no right.
Yes, Lordship. They don't have any say.
Then, and another thing is this, I find, I do not know whether the information is correct or not, that Supreme Court Collegium has also invited those secretary or the post holder to come and talk with the Collegium members about the withdrawal of the strike. Why? These are exclusively within the domain of the court. Court will decide what the lawyer has any role to play. Here is how the situation is here. They will go on strike sometime? No.
No,
And in Bengal, there are started, if you refuse to grant bail, you are a street judge, then and there they will start boycotting. And many courts it happens. But you are lucky enough that this is not happening here. So let me start of answering those queries. The first question, you have the list.
No, no, sir.
You have given me the list, no?
Yes, sir.
So you will just get it Xerox, otherwise. And circulate among all of them.
Actually, this list is gathered from everybody, the queries.
Oh.
No, I have not received any query.
They were. I thought others gave it.
Get it Xerox and circulate the copies and then I'll start.
I got it in the middle of my proceedings, so I could not.
How far your place from Gangtok to how far your place?
Mine, Lordship?
Yes.
It is here only.
Oh, near?
In Gangtok itself. They come from like 4 hours away.
I'm from the farthest west Sikkim, Lordship. It's 4 hours. Right.
4 hours? This is near Nathula or what? Nathula which side?
Near Nepal border.
Nepal border.
Nepal border.
And
Nearest
Nathula?
Nathula, we are nearest to Nathula, Lordship.
Nathula is near, Lordship.
Oh, you are near to Gangtok.
No, I'm pleased. We
Oh,
are in
Gangtok.
Gangtok itself.
Oh, Nathula is near to Gangtok.
Very close by, Lordship. Not only 48 minutes.
40 kilometers away.
40 kilometers.
First question, is it constitutional and legal to convict of an accused based on plea of guilty entered by him as a result of plea bargaining with the prosecution and the magistrate?
Yes, this is understood.
So,
Provision provides.
no, it is because it is already in the statutes books.
Yes, yes.
His legality and constitutional validity have not been challenged. Right. Next question is this, that this strategy, this policy strategy of the Gangtok, this thing, that now you see that the judgment of Gaurav, what is said, that judgment, where the 3 method has been prescribed. Policy strategy for grant of bail. This is the case we are dealing with now, according for which you are in this colloquium. There, this, you remember what I am saying? Do you understand what I am telling you? I am trying to tell you that the 3-stage methods. That is the case where Supreme Court has said referred the case about the plea bargaining. Therefore, this is one additional factor which establishes that plea bargaining has the constitutional and legal validity. And then again, you know that previous to this statutes have been these provisions up to this thing, the chapter 21A is introduced in the CRPC. There were few cases, Chandrika and Nuruddin. In those cases, Supreme Court has considered the provisions of 249 CRPC, 229 CRPC and 252 CRPCs. You please find out what these provisions are related to. I am once again repeating. 229,
Conviction on plea of guilty.
what is 241?
Conviction on
This is relates to summons case. Warrant case. 252.
Summon cases.
Summons case. And the 229 was sessions cases. Right? So in the old decisions, those are the decisions of the year 2000. The Supreme Court in those cases were on plea of guilty, as you pointing out, that merely they are saying without recording the plea, they have convicted or sometimes give some relief. The Supreme Court highly deprecated it. That you should not do it, because I must know, because your order is appealable order, that whether you have applied your mind properly, whether you have ascertained that they have voluntarily accept the plea of guilt, not that somebody from outside forced. Right? Therefore, we have no doubt that it has a this thing constitutional and legal validity. Next question is this: mere acceptance of or admission of guilt should be a ground for reduction of sentence. So, it is not mere, just I said that I agree to plea bargaining, the court is not to accept it, because there are different stages. That in the notice you have to clearly said, and after the notice law said that they have to be brought and they have to apprise of the pros and cons, that what kind of punishment you might get if you are convicted. So therefore you are applying all way, take all the trouble to make them understand what would be the pros and cons of this thing, conviction. Therefore, there is no doubt that we cannot say that on mere admission, acceptance or admission, that the plea bargaining is done. Therefore, it cannot be said. Third is this: simply on the basis of plea bargaining, can court dispose of criminal case without deciding on merits? What is your reply?
Yes.
Yes. So the question of merit does not arise in case of plea bargaining. But if it is on Probation of Offenders Act, you have to, first of all, you have to decide the case on merit. Then only you can apply provisions of plea bargaining, not before that. This is the third answer. Fourth is this: Section 361 CRPC says that court declines to entertain application filed under Section 360 CRPC, or then court has to record special reasons in the judgment. How court can record such reasons in the judgment after the same has already been pronounced? All of you have to answer it separately. But first follow the question, then try to give the answer. Look at the question. You have the question, no? This is very important question. I may explain.
Yes.
May I explain?
Yes, Lord.
That what they said, that 360 is Probation of Offenders Act. 361, court is taking decisions that in your case you are not eligible for 360. So the question is that after conviction, after judgment is delivered, that you have convicted. Now in 361, how do you give the special reason? Because writing of judgment is over. I am clear?
Yes.
Think over it.
At the stage of sentencing, Lordship.
Okay. Because after delivery of judgment is through 332, those are provisions you are very much acquainted. At the stage of sentencing, so you have to record. Suppose you are going to, have you passed any order of capital sentence? You?
None of us.
No, in Sikkim, no capital sentence. So therefore, because in the capital sentence, your job is most onerous. because you have to apprise them, you have to consider the mitigating circumstances. That you have to take in information about their social background, how they have born and brought up.
Rarest of rare cases.
Rare of rare cases is, we are saying from Balban Singh that rarest of rare cases. But now that it went further, that you have to first see, because before independence, you have to, capital sentence was the normal and the life imprisonment was exception. Therefore, you have to assign special reason why you have given the life imprisonment. Now it is absolutely reversed. In case of death sentence, the normal is side, and in case of death sentence, you have to write what are the special reasons. Therefore, it is incumbent for each one of you, while sentencing the person, to record a further order after conviction, why according to your discretion you fit. In case, this is not only in case of the sessions court, this is also in case of magistrates also, that while they are delivering the judgment, they have to note down why you are sentencing, what is the policy of sentence, that this much of sentence you have imposed. Right?
I have a question at this stage. What is the correct time to accept an application for probation? Is it after the court pronounces sentence, or is it along with the like at the time of fixing of the order of sentence?
No. If you already passed, just see, 1 minute. This is, you just see, may I draw your attention to section 3 of Probation of Offenders Act. So, if you find him guilty, as soon as you conclude that he is guilty of the offence, then the question of sentencing will arise. And at that stage, that stage, you have to decide the question whether this particular accused can be dealt with the provisions of Probation of Offenders Act. That would be the actual stage. I am clear?
Yes.
Which can be at the stage of framing of charge if he pleads guilty, or on the conclusion of the trial. Yes.
Suppose you are correctly that his plea has been recorded, is correct, that plea has been recorded, you have to note down that you have explained to him that merely saying that the charge has been read over will not do. You have to say, I have read, the charge has been read over, and also that it has been explained.
And he has voluntarily.
Voluntarily. I am satisfied. You have to record your satisfaction. That he has voluntarily said that I want to plead guilty. And then he is stated as follows. Then it is complete. So everything is there. Now after that, yes. Now, so he has pleaded guilty, and now I am proposed to convict him on guilt, on his admission of guilt, and to pass sentence. Then you will have to say that you will do another provision, apply the provision. You find that is a fit case, that suppose in a case of theft. So you have to say that you tell the accused that you at so and so time, at so and so place committed theft at the house of so and so persons. Then you said that I have also told them that for this punishment is this and that. So thereafter you said that he opted for pleading guilty. So he pleaded guilty. He recorded that yes, he admitted that on day he taken advantage that no one is there in the house, he has went and committed theft. So, and convicted. May not be necessary to write everything what I have said, but it is better to note it. Then nobody can touch you, that your judgment is not correct.
I ask this question because here, especially the young members of the bar, at the time of submission of the hearing on sentence only, they said that, and I'll be filing an application for probation, maybe with the hope note that, the sentence might be
At the stage of
hearing on sentence.
hearing on sentence.
They say that, and I will be filing.
No, repeat. I can't follow.
Lordship, at the time of hearing a sentence, before the court pronounces the sentence, they come ready with the application. And I have always...
No, that probation of offender has to be dealt with at the stage of sentencing.
Lordship, I'm talking about after conviction, suppose after conviction.
Before you decide.
That's what I'm saying, Lordship.
Before your judgment.
No. What she is saying, that before it is whose discretion whether the accused should be dealt with probation or not. Before, just after she pronounced the judgment, saying that I find you guilty, then and there the lawyer will bring out one application from their pocket and submit it and say that deal it with Probation of Offenders Act.
No, Lordship, most of the time they come at the stage of their submission on the hearing on sentence. Before the court pronounces the order on sentence.
After the sentence?
No. Hearing on sentence. Maybe with the hope of asking for some leniency and all, even in that. But ma'am, I feel that it is after the court pronounces the sentence.
No. If you pronounce the sentence, then you cannot apply the Probation of Offenders Act.
Application would be infructuous.
Lordship, I am saying this not because I am doing it, but I am saying this that here, especially the young members of the bar, they come like that. Even before, in fact, first thing before they make any submission of sentence only, they come with the application.
But that is the stage.
They can after conviction, you fix a date or on the same day. Now I will come to the question of sentence. If at this stage somebody says that release me on Probation of Offender Act, they can do.
Because you have to hear and consider this application, and thereafter in your order you will say whether you're going to give this benefit or not.
Right.
But section 3 says that or any offence punishable with imprisonment for not more than 2 years. And as magistrates we deal with
what you are referring to?
Section 3 of Probation of Offenders Act.
Yes.
That is admonition.
Yes.
we deal with 7 years also.
2 years. You are what do you say?
Then it will be 4.
4.
Then section 4 also.
Lordship, as magistrates we deal with offences which are from 2 to 7 years also.
Offences?
Which are punishable with imprisonment for
up to 7 years.
If it's not punishable with death or imprisonment for life, then it's
Under section 4.
3 is not more than 2 years. Madam, please come to section 4. Get yourself clear. You have the book with you. So you just see the section 4. Then tell me. That is the very first sentence. When any person is found guilty of having committed an offence not punishable with death or imprisonment for life and imprisonment for life, and the court by which person is guilty is opinion. So therefore you are a learned Chief Judicial Magistrate, you have the right to impose sentence up to 7 years. Even in a case, if an assistant session judge is holding a trial, so he can impose a sentence up to 10 years. So both in case of you and in case of him, this section 4 is attracted. You have to follow section 4.
Lordship, I have one query, Lordship. In Sikkim, we don't have a probation officer, Lordship.
That he has asked me, I am coming to that. This is next question. So, on this point, there is a judgment of the Apex Court. Take it. Read it. Come here and read it. Just podium, stand on the podium and read it for everyone. Come to me, I will show you. That dismissal of person convicted for entitled to benefit of that act, therefore should be removed from the right. Please listen carefully.
This is a case of Chand and others versus State of UP. Head note, probation of offenders.
And tell me where it is reported.
It's reported in 1972, 1 Supreme Court cases, 642. Probation of offenders, United Provinces First Offenders Probation Act 1938, Section 4, whether accused convicted under Section 304 IPC entitled to the benefit of the section and be released on probation, whether it is necessary for the court before applying the section to see whether any probation officer is functioning in the concerned district. The High Court convicted the appellants under first part of Section 304 IPC on special appeal. By special leave, the leave was limited only to the question of sentence and whether the offence as provided falls under the part of Section 304 IPC. The Supreme Court came to the conclusion that the offence falls under the second part of Section 304 IPC. The other question considered by the court was whether those appellants who are below 21 years should be given the benefit of the Probation of Offenders Act. It appears that the Central Act was not made applicable to the state of Uttar Pradesh, but there is one local act, United Provinces First Offenders Probation Act 1938, which was admittedly made applicable to Rampur state after it became a part of Uttar Pradesh. Held, the offence with which the appellants are being convicted falls under the second part of Section 304 IPC, and such of them as are under 21 years would be entitled to the benefit of Section 4 of the Act. This is a case in which the appellants who it was admitted were the first offender should be released on probation. There was no necessity to obtain the information as to whether any probation officer...
This line, please read slowly.
There was no necessity to obtain the information as to whether any probation officer had been appointed to District Rampur, because under the first proviso, all that the court has to satisfy was that the offender or which surety has a fixed place of abode and regular occupation in the place for which the court acts or in which the offender is likely to live during the period named for the observance of their conditions. In this case, it would be sufficient if the court directs the district magistrate concerned to conform with the requirement of that provision.
So therefore, relying on these decisions, we can say that even in absence of the probation officer, that you have in those cases, your task is more onerous. You have to satisfy all the things. Right? So you get
another point to be pointed out, Lordship, it says age was 20, Lordship, whether they can consider somebody who's age 20. And section 6 says anybody who's below 21 years of age in a duty is
No,
cast on the
the issue was that in absence of probation offender, in the district of Rampur, that was included in the united provisions. That
Apart
previously.
from that, I'm just mentioning.
So what I said that whether probation without the report of the probation officer, that whether that the accused can be dealt with under the Probation of Offender Act. This Probation of Offender Act came into force in 1958. This decision was delivered in the year 1972. Therefore already was there. So it has the manner of applications there. But what I say that that it will apply whole of India. Only thing required that government will issue a notification. So, but here there was already there was a provisions there which is perimeteria with the provisions of Probation of Offender Act. So question arose whether absence of the probation officer, whether that this thing can be done or not, that the court can proceed with the Probation of Offender. Therefore, it is not necessary. But why they are not appointing probation officer? Government? Mr. Sherpa?
Yes, as informed by the law secretary, they have already processed the file.
Oh,
and it had the file they have sent to the Government of India, Ministry of Law and Justice for, I think, necessary approval. That is pending since more than 7 months.
No, why it is to be sent for Sikkim state? It is union territory.
I don't know the intricate the issue involving that particular file, but this is the information shared by our law secretary.
No, why they have to send it to the Union of India for approval? What is the role?
Because section 13 says it is the government who has to appoint.
State government?
Yes,
No, but he said that the file has been sent to the central government.
It's pending for more than 7 months.
Section 13 is very specific, Lordship.
So then, why? That is what I am asking. That why for the issuance of the notification that they will send it to the central government.
Nowadays everything has to come from central.
A person is appointed to be a probation officer by the state government or recognized as such by the state government. Why they have sent it?
There is no role to play by the central.
No, you have any in your state? Do you have any this thing amendment?
No. This is central exclusive, and I don't know this the region. But the law
This
department
appointment, section 13, the state governments are appointed. Do you have a constitution? Yeah. I want yes.
But Lasit,
And you do have the rules relating to the Probation of Offender Act.
Lasit,
Rules. Any rule has been there.
No, Lordship, there is no state rules.
So, power to make rules. See section 17.
Lasit, here
Right, I understand what is the difficulty. You don't have the rule.
They don't have the rules, yes, Lordship.
Right.
Yeah,
Therefore, the rule has been sent to the central government, not the appointment. For ratification by the central. That is necessary.
Yes.
Under section 7, subsection 1. The state government may, with the approval of the central government, by notification in the official gazette, make rules to carry out the purposes of this act.
Rules have to be sent, Lordship.
So the rule has to be sent.
It has to be sent.
And that is pending for approval.
no this about rules there was no discussion. Simply I made query whether there is any probation officer appointed so far. Then he said the file has been sent to the
Who
government.
said? Judicial Secretary?
No, law secretary.
Law Secretary. What he said?
File has been sent for approval to Government of India, and it has been pending since 7 months.
So what file? Regarding appointment of probation officer, they are not obliged to send the file to the union of central government.
Lordship, perhaps they've specified the qualifications in the rules. For
That is the what I am
appointment
saying.
officer. So
That
that's
in
why
the rules that will have to be incorporated.
it has to be specified, Lordship. So that is what has been said. So about eligibility.
One thing, you can, yes, you find out from the Supreme Court online or anywhere that whether there is any, the rules for other state governments. Then it will be clear. Can you find out? Please find out. You have the library here, no?
Yes, Lordship.
Librarian is here.
Yes, library is here.
Call librarian.
Lordship, this 2005 says, AIA 2005-2658 says, the report of probation officer is mandatory.
True.
Eligibility criteria of the subject.
No, it's may I read, Lordship?
No, bring that. Mr. Sherpa is the senior most in the higher judiciary. Yes?
Madam.
Oh, you.
Second senior.
That is why sometimes he is telling nobody is that much of courage to say anything, but you are saying. That is I have noticed. You are senior most. So who is the Registrar General?
Mr. K.W. Butcher.
He is also junior to all of us. Junior to him also.
We were both in the registry for several years, Lordship.
Okay.
So then we asked for to be
To
transferred
send to
out
the
of
judicial one.
Yes, Lordship.
So how many years left? What is your age? Sorry,
Lordship,
retirement.
24 and retired, Lordship.
24.
Lordship.
So you have enough time. That is why you have sent for judicial work. I understand.
Lordship, I asked for the transfer because I was in the registry for almost.
Very rightly done.
Lordship.
You understand my hints. So you are the senior most judicial officer. How many judges are here?
Only
High
three,
Court?
Lordship. Only three. Lordship.
How
That's
many
not it.
posts are there?
Only
Sanction post?
three, Lordship.
3. So one from bar.
One from bar, one from judicial.
So the learned judge who is from the bar, when he is supposed to be retired?
Much
And you are
later.
from the judiciary?
26, Lordship.
26. Mr. Justice Pradhan. Who is? Pradhan is? From bar.
Bar.
Lordship, the Rajasthan Probation of Offenders rules is here, Lordship.
Just read it. So you can you bring go to
Choice of probation.
probation rules that you will get the Rajasthan.
Lordship, it says it has specific rules regarding qualification of salaried probation officers. Then it has general qualification for part-time probation officers. Then appointment.
Therefore the
That's
rules
right.
have been
That's
said.
right.
You are right.
Yes, Lordship.
Not the appointment. Not
That's
for
why
the
it
appointment.
specifies the qualifications, Lordship. That's why it probably is.
That is the reason for delay. Just see that how only 7 months back they sent the rule for this approval of the central government. What state government is doing here then? Through Chief Justice you talk to them. Or who is in charge? Madam.
Justice Bhaskar is the judge in charge of the Judicial Academy.
Who?
Of the
Justice.
Judicial Academy, Lordship.
Who is that?
Lordship, Justice Bhaskar, Lordship, he is in charge of the
Pradhan.
Yes. But overseen by the Hon'ble Chief Justice, Lordship. Functioning.
There is some other. And this is Meenakshi Rai.
Uh,
She's from Bar.
no, from the Judicial Services Lordship, and she's judge number 2 Lordship.
And Miss Justice Pradhan,
Is number 3 Lordship.
he is from the Bar. Learned director is going to bring that book, no? He's referring to this.
I think the judgment, Lordship. The
You
judgment.
have
No, he's, sir is going to bring
searching
the
the
judgment.
judgment.
In view of question number 6, probably.
That 6.
Yes. In the past, what we have done is because we did not have probation of officers lordship, but because we had to release some, we found some cases fit for release of accused persons under the Probation of Offenders Act. So we have given directions to the SHO of the area where the accused resides to ensure that he maintains good behavior lordship during that specified period. So on those grounds, we have released also.
That station house officer,
Yes.
police station.
Because they have immediate control over that person within that.
Also, you inform the
GM
the
also.
district magistrate
Yes.
also. It should be incorporated in the rule. That is the reason that the probation officer is not available. Not because of appointment file. They did not have to send the appointment of file. The rule has to be sent. That has not been done. Take a clear view that what is pending. Thank you.
Last one.
And that apart, one important thing is this. This is a decision of 2 judges bench. And the judgment of charge is of a 3 judges bench. So which one will prevail?
See, the in 2019 also.
Huh?
I'm displacing. Yes.
This is of which year? Laxman? This
2005.
2000 and 2009 decision, show me.
Yes.
2019?
Yes, we will try to trace out.
Okay.
Lordship, Lordship, if you look at section 4, subclause 2 of Probation of Offenders Act,
Section 4.
subclause 2, Lordship. If any.
Oh.
Then the statute itself is very clear.
You are referring to which section?
Section 4.
4.
Subclause
Subsection?
2, Lordship.
Oh, if any. I missed that. Thank you very much.
Because if the statute itself is very clear, Lordship.
And that apart, what Mr. Sherpa referred, that is a decision of the Supreme Court. 2 judges bench decision. That in the last line, no, they have explained it. It is what I am saying. In the case of Mohalingam versus G. Padmavati and another, Madras Court, observed as under, if any report is filed by the probation officer, the court is bound to consider it, full stop. Obtaining such a report of probation officer is mandatory since subsection 1 of section 4 says that court shall consider the report of the probation officer. Words, if any, quote unquote, do not mean that court need not call for a report from the probation officers. The word if any would only cover a case where notwithstanding such requisition, probation officer for one reason or other has not submitted a report. Right? Then, before deciding to act under 4.1, it is mandatory on the part of the court to call for a report from the probation officer. And if such report is received, it is mandatory on the part of the court to consider the report. But if, for any reason or other, such report is not forthcoming, that court has to decide the matter on other materials available to it. I do not think that this part is noted, quoted from, not noted, quoted from the Madras decision. And in the last line, it is the findings of the observation conclusion of the High Court, Supreme Court. I am once again reading it. Before deciding to act under section 401, it is mandatory on the part of the court to call for a report from the probation officer. And if such a report is received, it is mandatory on the part of the court to consider the report. Pausing here for a moment, I am referring you the last line, that is very important. But if for one reason or other such a report is not forthcoming, the court has to decide the matter on the other materials available to it.
Yes.
Mr. Sipa,
Yes.
Therefore, it is not that it is mandatory. And that apart, this is a decision of 2 judges bench. Justice Laxmanan and Ashok Bhan and Justice Dr. A.R. Laxmanan. And whereas the Chand decisions he read over
72.
22, where is that book?
3 bench lordship.
That is of 3 judges bench. They have not considered these decisions. How the 2 judges bench can say so? That this is Selat, Jagmohan Reddy and H.R. Khanna, the great luminous distinguished judges of Supreme Court. So, 3 judges bench will prevail, but you need not have to go into that controversy, that 3 judges bench will prevail or 2 judges bench will prevail. You need not have to. Please don't do that.
Then
So,
which bench should lordship? Which bench should lordship be?
According to the settled position, the larger bench will prevail. And the second decision you refer 2000 feet, it can be easily said that par incuriam, because it has not taken into consideration the earlier 3 judges bench decisions. So it is a par incuriam. So if they do not agree, they could have referred the matter to the Honorable Chief Justice for constituting a larger bench and to decide the question. Only it can be overruled by a 5 judges bench, not by another 3 judges bench. And also there is a caveat in the last line that what I said, but for the reason or other, one reason or the other, such a report is not forthcoming, the court has to decide the matter on the other matters. Now question is this, that report is not forthcoming means that report is not forthcoming after you call for the report, or it is not forthcoming because of the person concerned who will submit the report is not there. But I don't think that you are making any mistake. But what you said, as a matter of abundant caution, that should have always been done. The station house officer, Mr. Serpa,
yes,
you understand that what she is doing, she is also, when he is doing that,
What I had done many years ago.
Oh, so he has done that, asked the station house to look after that country.
To maintain peace and good behavior.
Yeah, so that whether he is doing. And the last question was difference between the provisions of section 320 CRPC and the Probation of Offenders Act. This Probation of Offenders Act will apply, as I have already told you, after the accused is found guilty for having committed an offence. And instead of sentencing him or her, you are to think whether he should be released on Probation of Offenders Act. Whereas section 23 provides for composition of an offence under the said section shall have the effect of an acquittal of the accused. So one is an acquittal of the accused, and another is that if you release him on probation, this conviction remains. But that will not disqualify him.
But 2019 says different thing was.
Ah.
Who is that 2019?
What's it?
So just so.
হ্যালো, এই আমি এখন একটা এতে আছি সিকিমে। in your area, state, the lady officers are more. No? Okay, good sign.
In fact, we have two more on
Yes,
online.
I have taken both of them to consider. One is male and another is female.
There is another lady officer.
Another lady officer.
Two more. Oh, Ranjita, ma'am, two more.
Oh, this is about this disqualification.
Three more.
So this is on the moral turpitude, and not on the if the Probation of Offenders Act applies, that will disqualify or not. That is the question you sent to me. Yes. The released on probation does suffer a disqualification attached to a conviction under any law. So in this case, that is on question of moral turpitude. Was that man released on Probation of Offenders Act?
So that issue is now discussed in that.
Here. We should discuss.
Was it the hypnosis should proceed?
Where?
Hypnosis.
Yes.
Release on probation does not entitle employees to claim right to continue in service. Observation in criminal code.
The release on probation does not entitle employee to claim right to continue on service. The criminal code are not binding on employer.
Yes. So even after release on probation, that is criminal code, department declined to.
No, exactly we have to understand this, what they have said. Where in which paragraph they have said.
Here the paragraph is just
No, that mean not mentioned. Let me find out.
paragraph.
Yes, this is in paragraph 5. The relevant portion is yet another reason given by the High Court for interference with the order of discharge is that Criminal Code released the respondent on probation only to permit him to continue in service. The release under probation does not entitle an employee to claim a right to continue in service. In fact, the employer is under an obligation to discontinue the services of an employee convicted of an accused involving moral turpitude. So, observation made by the criminal code are not binding. One more. But here also, this is the same thing happened. Both are the coordinate bench, and Rikharam is a 87 decisions where Supreme Court says that it will not disqualify. Since it is statutorily provided that an officer, you just see that they firstly pointed out that relevant provisions. See, it is statutorily provided that an offender who had been released on probation shall not suffer disqualification attaching to a conviction of the offence for which he has been convicted, notwithstanding anything contained in any other law, instead of dismissing him from service, he should have been removed from the service, so that order of punishment did not operate as a bar and disqualification for future employment with the government. And that
This provision was in existence at the time of passing judgment.
no, but
On moral turpitude grounds.
moral turpitude.
Yes,
But
the court has now.
Court said that it is not a moral turpitude. Simpler. Section 12. It is clear that notwithstanding anything contained in any other law, a person found guilty of an offence and dealt with under the provisions of Section 3 or Section 4 shall not suffer disqualification, if any, attaching to conviction of an offender under such law. So therefore, again it is a per inquirium because that has not been taken into consideration. Section 12.
Yes, sir.
Is it not? What do you say? The Section 12 is very clear.
Yes, sir.
No, another thing what is passing in my mind, when want to be exercised, a court to be exercised, the power under Section 3 on 4, they have to take into consideration the circumstances of the case, including the nature of the offence and the character of the offender. If that be so, then in case of moral turpitude, you will not release. Will you release? Suppose he has sexually assaulted or passed a sexually colored remarks against any woman or other offences. 354
Yes,
A, B, C.
The Honourable Supreme Court, I recall, had specifically in a case involving Section 354 had refused, had not allowed this.
Not only the Honourable Supreme Court.
That was just a few years ago.
Lordship, there is one case, Lordship, in KPS Gill.
Okay. Read it. Chalo, let us go. So now he's asking for going to lunch. Just see. Please use judgment. Now let me start. let me start with bail. Out whether the word bail, term bail has been defined in the CRPC or not. Where you will find definition of bail. What the youngest you recently joined and other one. So most of you just before joining have studied a lot, I understand. So you tell me the definition of what is the definition of bail. Find out from the book. You also search. You also search. He's saying no, there is nowhere. So bail is a word not defined anywhere, but has been referred in various sections. Is it not? So what is bail? Bail is an undertaking from the side of the accused, either by himself or through his sureties, that he is furnishing a bond with the promise that on the date fixed for trial and when he will be summoned to appear before the court, he will make himself available. This is what we call bail. So, in CRPC, how many kinds of bail are there?
2 kinds.
What are those?
Anticipatory bail, regular bail.
And all of you agree? Huh? All of you agree. But there is a default bail in 167.
Default bail.
And there is another bail that is in fact is suspension of sentence. 389. There also, when the appeal is admitted and sentence is suspended, you release them from there. So there are 4 kinds of bail. One is default bail, another is anticipatory bail, next is bail, regular bail, and other one is suspension of sentence. That is also bail. Now, question is this, that how one should approach the bail. So far as 167.2 is concerned, tell me what is 167.2? What is default bail?
In a case, Lordship,
No, let her say. Junior should say.
When the charge sheet is not filed, the accused get a right, that's a statutory bill right.
Right. Okay, stop. This is called indivisible right. Indefeasible right. This right cannot be denied if no charge sheet is filed within the statutory period. In case of offences, tell me then, what is that time limit?
90 days.
For?
60 days if the offence is punishable with less than
With
7 years.
7 years? No.
10.
10 years. Alright. And then above 10 years?
90 days.
Now according to you that default bail, question of default bail will arise if we either within 60 days or within 90 days charge sheet is not submitted. Right. So this, suppose you file a charge sheet, not file charge sheet. So accused has applied for statutory bail. So what is the due on the 90th day? Accused file the application that will release me on bail. So actually, you tell me by default bail, what are the power from which the magistrate court is deprived?
You cannot remand beyond.
Huh?
You
You can't follow.
cannot remand beyond that period.
Right. Therefore, period of the right to authority to remand an accused has been withdrawn. He cannot remand. Therefore, on the 90th day, if accused file saying that the charge sheet has not been submitted, then what is the duty of the magistrate? Huh? On the same day, no? But on that day, if the accused said, Your Honor, I cannot fund this bail bond now, here and now. Kindly give me 2 days time. So 2 days were granted. But on the next day, charge sheet has been submitted. What would be the effect?
He'd still be entitled to his bail.
How? Because not only that, he has to point out that charge sheet has not been submitted. He has to say that I am ready to offer bail.
Offer bail.
But thing would be otherwise if he filed a application for default bail and court kept it pending for consideration. In the meantime, charge sheet has been submitted. But where there is on the part of the default, on the part of the accused to fund his, say that I am ready to fund his bail bond, then the right will go if the charge sheet is in between filed. Therefore, in most cases, Supreme Court can also consider whether without furnishing bail or in PR bond, he can be released on bail or not. Personal recognition bond. So, now Supreme Court has sometime in 2018 or 19, I can't exactly remember, in one of such cases, a 3 judges bench has taken up the issue for consideration. Previously, there are many cases, almost all are coming from Maharashtra. Uday, Hitendra Vishnu Thakur, Sanjay Dutt, the filmster, those are the questions. So Supreme Court every time says that it is an indefeasible right. It cannot be defeated by merely by the court, by merely keeping it adjourning that matter for consideration on some other days, or by thereby facilitating the investigating agency to file the charge sheet. By this way, it cannot be.
But
So,
if I may share, recently we had a matter where, because now we have filing is online also, Lordship. So what happened was, it was very interesting in the sense that the 90-day period lapsed during the Durga Puja vacations, Lordship. On the day the court opened was the next day after the 90-day period. But on the day the 90-day period was over, the advocate of the accused filed his bail application online. The next day when the courts opened, Lordship, the petition was returned because there was some defects noted in the petition. And then later the matter was taken up for hearing, and the bail was denied.
by whom? You?
No, the magistrate
No,
concerned.
not. Excuse me. But which magistrate?
Some other magistrate, Lordship, I don't mean. But
No, not present here.
not present. So the matter came in appeal, and then I allowed the bail application, saying that it ought to have been granted because it's an indefeasible right. Because the correction of, that was my opinion, Lordship, correction of default, in the petition would not be a sound reason for denying him his constitutional right.
One more thing is this, that now in that case, Supreme Court has defined many things. What are those? That what what is the mode of application for bail? It is said either it is by way of writing or by oral. That is sufficient. Next, in the bail application, what should be there? It said that only thing you have to point out that I am in custody since so and so date. Today is the day, the 90 days is over, and no charge sheet has yet been filed. That is sufficient. No more things is necessary. No more thing is necessary. This is enough. So in your case you are pointing out what was the defect?
Arrest memo was not filed also.
Arrest memo why will file? He will mention it is for the prosecutor to say.
Now, Lordship, many of the prosecutors, they take the plea that in the meantime the charge sheet is filed, and because nowadays a lot of these applications are filed online, so we should consider actually the date of filing online, Lordship.
Right.
That should be taken as the date of filing, Lordship.
This is by mail.
Yes, Lordship. Online filing.
Another thing Supreme Court has said that the lawyer, paid lawyer or the lawyer engaged by legal aid have the obligations to tell his client that a right has been accrued in your favor to apply for statutory bail. And then the next line it is said that court must inform the accused that you see that today is the 90 days. Till late, police has not submitted charge sheet. And a right to default bail has been accrued in your favor. This is the judgment says. Do you want that reference? Huh?
Yes, I think if Lordship gives it, will be helpful for you.
Huh? Hello?
Yes, Lordship, if it can be supplied, Lordship, so it will be helpful for everybody.
I am sure that she has rejected that bail. Otherwise, you could have. How could have you said that because arrest memo was not there? Nobody says.
She is under probation of training.
We were training. Ask your library.
Because in the meantime, the charge sheet was filed and there was Durga Puja vacations and all
No, I
that.
follow.
So, yes, Lordship.
Ask your librarian to bring this book. Librarian is there, no? Come. Actually, I am editing a book. That is CRPC, the LexisNexis. That CRPC by Sarkar. So every day I am studying a lot on criminal law. And previously I was a defense lawyer, so I had a practice in criminal law. My senior was a very famous lawyer. He was the Advocate General for pretty long time in West Bengal. Mr. Balai Chandra Rai. I don't know whether you have heard his name or not. Have you heard?
Yes, sir.
So you have heard. So I was with him for many days. Thereafter I became the judge, and whenever, only for 6 to 7 months I took the constitutional bench, read bench, singly, and Chief Justice was sitting for a long time. During that period I also take, but together with the criminal matters, and by the rest of the time I only take the bail matters. But equally I am interested in this writ matters, not on pure civil matters. CPC is not my subject. So, this is the, so 167, this is the latest point. Therefore, you should remember one thing, that the moment they will file the application for, what are the necessity? A few things. That these are the things you have to do this. If that is there, that only he said that, pointing out that this day I was arrested, today is this day, charge sheet has not been filed, this offence, the maximum punishment, you need not have to say that maximum punishment is this much, so release me on bail, statutory bail, grant me statutory bail. This is enough. No, nothing more is required to be added. That is sufficient. And if it is filed that neither the prosecution nor the court be permitted to delay the matter and thereby facilitate the investigating agency to take advantage out of that and submit charge sheet. That is, in long and short, this is what said by the Supreme Court. So you two have to be very careful about that. You have newly joined, no? So you are taking bail matters. For that remand application is filing before you, either of you.
Lordship, I am undergoing 1 year training.
What?
1 year training period. I have not taken charge yet.
I don't follow what you say.
Lordship, they are still under training. They haven't been
Oh, acha.
assigned the court.
So who is taking this CGM? You CGM, no?
For Gangtok district, I am taking East district. For East district, Lordship, I am the remand judge.
You are the remand judge?
Yes.
And you also. So be careful. The moment they will file 167 application, you will consider only thing whether 90 days has been expired or not. But wait till that day, because 90 days will expire on the next day. But on the next day you can very well hear that within 90 days they have not filed the charge sheet, and on the 90th day this should be your kind of order. This it will be free from any lapse. That on so and so day he was arrested, on so and so day these are relating to the offence punishable under section so and so. The maximum punishment prescribed is 90 days, would be 90 days because punishment is so and so, 90 days. To yesterday was the day, 90th day was expired, and yesterday itself the accused filed seeking statutory bail, and this it is expired and so therefore statutory bail is allowed. Can you cancel statutory bail once charge sheet is submitted? So under what circumstances you can cancel the statutory bail earlier granted? Yes. So conditions of bail are violated. So that is, you have to come down to 439(1). Is it not? Yeah. So you tell me what kind of problems you faced in dealing with these kind of cases. Yes, the charge sheet not filed within the statutory period.
So in fact, there was a time when even the remand lawyer as well as the legal lawyer was not aware that the charge sheet had not been filed. So I had to call for the file and in fact inform the parties.
So that is good. Then have you seen the judgment? The judgment I am referring to. Very good, very good. While releasing an accused under 167(2), can you impose condition? Let them see.
It's a bail regardless, it's a bail.
No, yes, condition. That while releasing, that condition that after being released on bail, you shall not enter within the jurisdiction of this police station, or that you will remain outside, or you shall remain within this jurisdiction and not went out. Can you? No. Why not?
No, Lordship, because this is an indefeasible right which has accrued on the
Right accrued, right to bail.
Right to bail.
But where it is said that it is unconditional right. Suppose suppose you know that there are many patch-up between the accused and the police. And mostly the ordinary people implicated in mostly in the matrimonial offence or others thing, they will not be able to manage the people. But sometimes the people who are involved in scam or other offences like murder or this thing kind of organized crime, this thing, they manage, and therefore after releasing on bail, they will come out and they will start manipulating the evidence. So therefore, why not you will be able to impose condition? Normal condition can always be attached. That on being released on bail, you will not deceive the witnesses or tampering with the evidence. That can always be there. So, this is all about 167(2). Now, let us come to 438. Tell me, what is the position of law, whether anticipatory bail should be for a limited duration or no duration till the termination of trial. Anticipatory bail, the duration of anticipatory bail shall continue till the termination of trial or shall be for a limited period.
Lordship, there is no time limit. The Supreme Court has said that there is no time limit and it is a discretion of the court. Once the trial begins or to the end of the trial, the anticipatory bail can be given.
Yes, you are saying something about this duration. Are you going to say something? So where from you get it?
Lordship, I forgot the name of the case, but then I had studied when I was preparing for this.
What do you say? You all senior judges, you are dealing with anticipatory bail.
This provision provides a thing for interim bail, Lordship. So there is a provision where it is for an interim period after which you hear both the parties, Lordship. Thereafter you can, section 438 says interim bail also, Lordship, you can grant.
That is a different thing. Interim bail not to arrest order.
Yes, Lordship, till such time. Then you can.
No. But if the anticipatory bail application is disposed of, can you say that this is up to this? No. You?
After the filing of the charge sheet, when the charge sheet comes to the court, the case has to appeal bail.
Yes.
Because till the conclusion of trial it can be
Previously, in those cases, Sunita Devi, Adhir Chandra Das, that ISKCON, two what is the monks, no? That the sannyasi were fighting with each other in ISKCON, Calcutta. So, this is the issue of anticipatory. Whether that time Justice Orijit Pasat was there, he said that the anticipatory bail should be for a limited duration, 4 weeks, 5 weeks. In the meantime, if you go to the court and surrender, you will get the release. Thereafter, in 2012 or 13, this case was before another division, which presided over by Dalbir Bhandari. That case name was some Matre. In that case, Dalbir Bhandari says that there cannot be any duration fixed. If you have to grant bail, it will to continue till the termination of the trial.
Or until he violates any condition.
Or that is a different issue. Then the matters went to a larger bench, presided over by Justice Arun Mishra, who was a former Chief Justice of Calcutta. So that is the case of Sushila Devi Agarwal case. In that case, Arun Mishra said that that case you find, then it will be clear. So ask somebody to bring that decision. You have Supreme Court online here, no?
Yes, sir.
You can see.
Find out, who will find out? Librarian. 1 minute. No, ask her, send her, that is sufficient. I have to find out one case. Sushila Agarwal. Under the heading 438. It must be has been delivered sometime in 2019 or 20. Bring that decision. And also one Matre, that is also under 438. If you find out the Sushila Agarwal in the case cited or considered, you will find the reference of that decision also. That book has been brought. I have brought one.
civil lawsuit. Criminal one lawsuit we are not having that. Let me see.
Where is my note sheet? You have handed over to her.
Yes, what you've taken it to the.
You use your online.
Yes, what. Sushila Agarwal is.
Got it? Read the last line. The ratio of the decision.
Says analysis of the case logic. Thus, having discussed about the several.
Listen carefully.
Thus, having discussed.
You take the mic.
I think this is not working.
He is working.
Hello?
Oh, light is not on. Oh.
Thus, having discussed about the several judicial pronouncements of the apex court, it can be rightly said that there is no such hard and fast rule in the grant of anticipatory bail. In reality, the discretion is of the court which is adjudicating the anticipatory bail application. The court, while granting anticipatory bail, should follow the fundamental canon of criminal jurisprudence that every individual is presumed to be innocent till he or she is found guilty. The main purpose for incorporating section 438 in CRPC was that the liberty of an individual should not be unnecessarily jeopardized. Right to life and personal liberty are one of the important fundamental rights guaranteed by the Constitution, and therefore no person should be confined or detained in any manner unless he has been held guilty. Anticipatory bail is one of the foremost.
You are reading from the, how many judges bench decisions you are reading from?
It says Sushila Agarwal and others versus State of NCT.
How many judges are there?
Court, it just says court number. It has not said number of judges.
You also find out from the
Oh,
online.
bench here, Lordship. Justice Arun Mishra, Justice Indira Banerjee, Justice Vineet Saran, Justice M.R. Shah, and Justice
Yes,
Ravindra
you are
Rai.
reading the correct judges. Yes. Because it was, first it was two bench decisions, then it went to the larger bench. Then,
So it says anticipatory bail is one of the foremost hotly debated subjects within the Indian criminal justice system. While on one hand it is said to be the custodian of the basic right, Lordship, maybe I think in this
yes.
is just...
No, not in this, last paragraph you come. About the duration.
No, Lordship, this is a concise version of the judgment, Lordship.
Oh, not the entire judgment.
Lordship.
So you have the online, Supreme
Yes,
Court
Lordship.
online. That's why it will not come.
This was a shorter version.
Librarian is not expert. Your librarian. You searching. Huh? Yes. This is the decision. You come to the last paragraph. Last paragraph. Yes. I am sitting back to you. Okay. Don't mind. So, the observation of, just read. You are able to read?
Yes, Judge.
Siddharam, Matre verses and the others, that no restrictive condition at all can be imposed while granting anticipatory bail are hereby overruled. Likewise, the decision of Salahuddin Ahmed Sheikh and state of Maharashtra and subsequent state of Adhiradharan Das and so, Nirmal Kaur, which lays down the restrictive condition of terms limiting the grant of anticipatory bail to a period is hereby ruled out. So you back, brought down, 1 minute. Where is that paragraph? Where is that paragraph? Just up. No. Down. So you bring down. Just a minute.
Till the end of trial, also.
Para one. Come. No, this is the reference. The court holds that protection granted to a person under section should not invariably, yes, thank you very much, invariably limited to a fixed period. It should inure in favor of the accused without any restriction on time. Normal condition under section, if there are specific facts, it is open to court. Yes. If there are specific facts or features in regard to any offence, it is open to court to impose any appropriate condition, including fixed the nature of relief or is being to tired an event. As regards to the second condition referred to this court, it is held that life of duration of anticipatory order does not end normally at the time and stage when the accused is summoned by the court or when the charge is pending, but can continue if there are any special peculiar features in court to terminate bail. It is open to do is. So therefore, in a special and peculiar features nature, the court can limit the tenure of the anticipatory bail. That is what Supreme Court in larger bails matter case. And you find out the Matre's decision, it is referred here. Siddharam Matre. Yes. You are holding which post? Huh?
software program.
And legal background. So you just find out the last this ratio. In our considered view, the brought down. Again you find out where is the paragraph. See, commonplace. Please come. This decision of the court. Just this one, this para. There is there is no such limitation on the anticipatory bail as per the statute, but the same entirely lies on the discretion of the court. If the court issuing the order of the anticipatory bail has any reason to believe the inclusion of such conditions is necessary, it may put them in while granting the said order of anticipatory bail. Thus, this means that any limitations or conditions which are not specifically mentioned in the statute are completely at the broad discretion of the court issuing the said order. The judgments rendered in Salahuddin Abul Samad Sheikh, Sitaram, Satlingpa, Matre, K.L. Verma, Sunita Devi, Adri Dharandas. Alright, that is enough. Give me. So therefore, the question of duration of anticipatory bail, it is for the discretion of the court. Suppose I am giving you one example. So a father come and made a complaint that his daughter has been eloped by some boy, and his parents are very much involved in that case. So court thought their plea was taken that what the parents will do if the boy has he has an adult boy, the girl is also adult, they have affairs with each other, so he has gone out. So this question arises. So therefore the court can say that this anticipatory bail is granted till the recovery of the girl and her statement under 164 is recorded. Because as soon as the 164 will be recorded, you will be sure that whether it was voluntarily she left, if therefore no case will stand, and if this says that whether he is implicating the parents of the boy or not, that will also be clear. Because if they are involved, then you will say that they are actively involved, or give some facts from which you can ascertain about their involvement. That I get out from my house, I went to the boy's house and stayed there for 2 days. Then his father said and mother said, not, you should not stay here now because your parents are searching for you. You go to one of my sister place, right? These are the things said. So they are actively involved. They are abetting the offence. So now it is found that the girl is below the age of consent. Right? So here, not only the boy, the parents are also involved. So therefore, if you limit, if a cut down period is given, that after the recovery of the girl, it will continue. So after recovery of the girl, if it is found that there is no involvement of the parents, the anticipatory bail shall be granted. After recording of her small 64 statement. Is it not? What do you say? Yes. What do you say?
If the court presiding over the matter feels so, then Lordship, they can impose that condition.
No, I am giving you one example of a particular case. This is the factual background. I have just, we are dealing with an hypothetical situations. That in one case it happens. That they came with the allegation that the father, that my daughter has been eloped by a boy of our locality, and I believe that her and eloped, and thereafter he left his house, and I am sure that unless his parents are involved, this could not have been happening. Right? So now the lawyer said the boy has went out with this girl. They never came to my client's house. Never came to our house. So therefore, why you are detaining, police is asking, wanting to take my client in custody. They are old man. Right. So in this case, the court thought that yes, anticipatory will be granted. But till the date, the victim is recovered and R167 statement is recorded. And after that, the court concerned, the matter is pending before the court, will consider whether this is a fit case for granting bail. So after the girl was recovered, her statement was recorded. She said that I am an adult. I am on my own, I went out.
Then no case, Lordship.
No case. So they will get bail. If she is minor but said that I from my house, because I love the boy and my father was arranging my marriage, therefore I have fled away the boy. From my house we picked up a bus and went to that place. What this shows?
It was still voluntary, Lordship.
Not only that, about the parents' involvements have been excluded completely, because they never went to the parents, this boy's home, and it is not the case that parents help them to flee away. So therefore they will get the anticipatory bail.
Rather, Lordship, the girl's parents might get into trouble
Yes,
for trying to marry
because
a minor, marry off a minor.
that is the prohibition of child marriage. That is the thing. So, you tell me, in one case it happened, I am giving you one example, that election declared. Right, listen, interesting case. Election declared. The two contending candidates, there are few candidates, but two candidates are from big party. One candidate one day came and offered puja to a particular temple. And after leaving at the time of leaving the temple, he had, before a small gathering, he said, don't be afraid of the oppositions. If they use any force against you, I tell you, you also use force. And don't allow anybody to, don't let out anybody if they use force against you. I am here, I will protect you. He left. After 2 to 3 weeks, another candidate came. He, after offering puja, while he was coming out from the, temple, he was surrounded by a group of people who belongs to that opposition party. And first of that, there was some altercation took place between them. Then there was a free fighting and one person was killed. And the party that this political leader who was assaulted and whose supporter was killed, from their side a complaint was lodged to the police, telling that involving the other candidate who about 4 weeks back visited the temple and at the meeting said that don't fear anybody, if force is used against you, you also do that. Don't spare.
Lordship, and these same people are the ones responsible for the incident that followed?
Yes. But it finds from the case diary that there are several number of eyewitnesses. They have seen who was present because some injured witnesses are there. They said who were in the melee, who were in the assembly, who took part in the assault, everything. But they do not refer the name of these two, the candidate and his brother. Those now who have been implicated on the ground that they were without their instruction, it cannot be done. So what should be the approach of the court? That when these two persons come to the court for seeking anticipatory bail.
Lordship, number one consideration would be whether there is apprehension of their immediate arrest.
No apprehension of immediate arrest there because they are named in the FIR. But the role attributed to them is that on the 4 weeks back they came and on that day they held a meeting in the open field and they said that if they forced you, use force against you, you also do the same thing. Don't spare any of them.
Lordship, the grounds that ought to be considered while considering a bail application under this provision is that, number one, we have to see the gravity of the offence involved also, Lordship, and whether there is a chance of this person fleeing from justice and also his antecedents, Lordship.
That is what you are summarized the principle of granting anticipatory bail. I am not asking you that. I am asking what should you be you suppose you are the judge. You are sitting before you that they have applied before for anticipatory. What you should do? You will grant the anticipatory bail or not? Whether according to your views, whether this is a fit case for anticipatory bail or not.
Because I feel that they have incited, Lordship, I will not grant you, incited the crowd which has resulted in the loss of life of somebody.
Let us take it as it is a debate.
Yes,
You are in the motion is bail should be anticipatory bail should be granted or not. You are from the side that the bail should not be granted, and you are from the side that bail should be granted. Now develop your argument. You take help of others. You all four in the same team. So you think over it. Take their help. You follow my argument case. First of all, you tell me that whether you have followed what I am saying or not.
Yes.
So let them do, okay. They are the junior members. One day they will acquire the jurisdiction to decide the question whether anticipatory bail should be granted or not. So beforehand they be trained.
For the sake of clarification, could you please tell us the facts again?
I can't follow. You just be
For
close
the
to
sake
them.
of more clarification, could you please tell us the facts again?
Okay, I want to
Yes,
repeat the
Lordship.
facts.
Yes, Lordship.
election is declared, right? So candidates, one of the candidate came to a particular temple, offered puja, and while coming out of the puja, before a small gathering, who are supporters of his political party, said that today I am leaving, but be careful and take care of yourself. If anybody from the opposite side use any force against you in any manner whatsoever, you don't spare them. Don't flee away from the field, retaliate, and I will be here to protect you. He went away, that candidate. After about 2 weeks, the other candidate came to offer puja. He offered puja. After offering puja, he is coming out from the temple. All of a sudden, he was surrounded. He was with him, he was his supporters. The supporters of the rival political party surrounded them from all sides and first started pelting stone and abusing. So altercation took place, and finally one of the supporters of the candidate, second candidate, who was that day went to offer puja, was assaulted and killed. So now from their side an FIR was lodged. So in the FIR, the injured person lodged the FIR. Police recorded the statement of other injured persons, also the statement of other local shopkeepers, and also the statement of the persons who were at that time in the campaign. All of them mentioned the name of the persons who took part in the actual assault and who in what manner assaulted them. At the end of it, in the FIR it is alleged that it is because they are also involved. The other candidate who for about 4 weeks back visited the temple also equally involved, because without his involvement this incident cannot be happened. They did not be they could not have committed this crime. They are also involved. So police started a case, not only against the person who took part in actual assault, also against the candidate and his brother as the named FIR named accused. They apprehended arrest because they are named in the FIR, and police is searching. They applied for anticipatory bail. You are a judge sitting, and before you the application for anticipatory bail has been filed. What you will do? Grant anticipatory bail or not? Your approach I want to know. Don't think before you are not sitting in a division bench. You are sitting singly. You?
Yes, sir.
Grant. Yes, you?
I grant the answer.
You?
I grant the question.
Why? But your senior most judge said that no, I will not grant it.
I usually don't grant bills.
I will grant because, Lordship, one reason is because he was not actively involved in the offence, and secondly, he said that okay, I will, if there is any force, if somebody uses force, you can retaliate. But he was not actively involved in that murder.
And not present. Yes. In a situation like this, Supreme Court granted anticipatory bail. Say this is a fit case for what on your logic. In another case, what happened? A boy took away the girl. They were together. So father rushed. So after few days, the boy married the girl. When she reached that, a few days was left. 1 week to become adult. So after 7 days is over, immediately they got married. So now police said, very difficult, father is a very influential person. He said police at any cost the boy to be taken into custody. But the girl in her 164 statement said that I myself on my own volition left with the boy. And I know that I should, because I am minor, and 7 days we are waiting. We had the affairs for last 2 years, and we have decided to marry each other, but we were waiting since I was minor. But somehow or other, my parents have changed the occasions, our intentions. So he arranged a matter and my marriage, and that has to be taken place in between this week. So before that, I have left with the boy on my own volition, and after I became adult, I have married him. So this is a good marriage, neither void nor voidable. Right? Now the father is a very influential man, and what he said, that he said, yes, all right, police asked the police that you somehow or other you get the boy inside the jail. And one thing I missed to say, that on the date they left out, right, they went to the temple and vermilion was put on her head, and there was some rituals followed. So these are the facts. So what police did, when find that the case of kidnapping or abduction, although they are dead, will not sustain finally, because by now they have added that all that fact that he has went away the kidnapping, case of kidnapping, because on that day minor, but it is there that a consent, when you are reading the case, you find that she left with her own volition. There was no inducement or anything. And they said that affairs was continuing for 2 years. And since father arranged the marriage, and that habit took place within a week, they took the decision to flee away. And after fleeing away, they went in a temple and got married. So police not only added the 360 kidnapping cases, also added the section 9 of the Child Marriage Prohibition Act. That is a cognizable offence and non-bailable offence. So question arose whether the boy should be granted anticipatory bail or not.
If I were a judge, I would have allowed the anticipatory.
Just see, that one strict judge is also saying that I would have granted bail. You are a liberal judge, and those who are sitting in the last bench, they are all liberal. So, right. So therefore, it is a fit case for granting anticipatory. But in a case, suppose in a case of murder, you find that that eyewitnesses said that they took part in the assault, or sometimes it happens that they said that although that boy was in the group, but he did not actively took part, but raising something that instigating the others. So that case, granting of anticipatory bail would not be proper, in my view. But actually it depends on your discretion. I said that at the beginning I said that I am not training you, I am not teaching you anything. I am only telling you the way how to learn. That is the important thing, how to learn and how to take your decisions. I am just guiding you, sharing my experience with you. So therefore it is your decision to decide whether you will grant bail or not. And what you have said, that are the principles of law. That while granting bail, it is better to refer in your decisions that after it I find that there is a little chance, suppose in a case of forgery, serious case, but you find by that time police has recovered the forged document and it was already sent to that handwriting expert for examination and report. So in that case, record has been seized, you will not be fleeing away, you have your permanent home, and have a deep root in the society. So that case, you can consider the question of bail, although allegation is very serious, that a valuable document has been forged. That is the allegation, but it is not still been decided whether it is forged or not, because it was going to the handwriting expert for finding out their handwriting, whether it is matched with the original sample, that the offending handwriting and the actual handwriting, whether that matched with each other or not. Normally, what is the recent trend of bail? Normally, Supreme Court said that where charge sheet has been submitted, investigation is over, and there is no chance of absconding or this thing, allow the bail. Or where the trial has been commenced, but other accused are on bail, but this accuser is in custody, and trial is continuing until late, and there is no likelihood of trial being finished within a short time. So when this on the ground, maybe that's not actual parity because he is the actual assailant, not the other two who are on bail. So let them be granted bail. This is the recent trend.
Yes, Lordship, and because also we've been receiving instructions from NALSA also
Yes.
regularly nowadays to keep on reviewing all the
Decisions
of under trials and to release them on bail.
Previously, view was that once it is rejected, once our time I find one decision that you rejected the bail. So Supreme Court said, though next time when you will find the successive bail application or will come for renewal of the bail, the application should be go to you, not to him. That was a strict view. Now they are becoming more liberal. They are because of, not because otherwise, but because overcrowding in the jail, and this is the main problem. Supreme Court has now become, sorry, with all respect I says, that become wise. That this should be otherwise, that overcrowding in the jail cannot be controlled. One. I'm just coming, okay. Oh yes, you taken out it.
It's become so liberal that Rajiv Gandhi in the assassins they out. Lordship, it's become so liberal that
Nalini.
Yes,
Nalini.
Her relatives are.
But the victim, I will tell you that story. I'm coming and
No, but the interesting part was that, remember we went for that program? NALSA program? Not NALSA program, yeah,
Yes.
and then that movement was there to release, and everybody. As soon as we came back, what happened? That, what is it? Bilal, I know, what is that famous rape case, Gujarat?
Yes.
All of Modi's people were there, no? Immediately they were released. So it appeared almost as if this whole...
So, this news came up in the paper that what is the girl who carrying the suicidal bomb?
Nalini.
No, Nalini is not that girl. She has lost her life.
Oh, okay. The suicide bomber. Not bomber.
Huh? Kya? Oh, yes. Dalu.
Something like that.
Dhanu. A lady police officer was posting at the spot. He was the part of the ring. You know what is called ring?
Yes.
That in case of VIP, there will be few police officers will be posted. They will, you don't understand, they will without uniform. Not like other uniform, they are, now it is upgraded, and now the NSG commandos are forming the role. They have a screen, they have in the bag they are carrying many things, and protecting curtain, bulletproof curtain. Immediately any attack is, any fire is shot, they will put this blanket. So this will cover the Prime Minister. No bullet will enter inside it. It is bulletproof curtain. So what happened, because normally what you will carry with you if you want to kill? You will not bring the machine gun or tank. You will only pistol and other things, short terms. So she was on duty on that, at that spot. So according to her, she suspected the movement of Dhanu. Right? So he want to remove her from there. One of his, and there some altercation took place between them. Then the senior police officer came and asked her, spare her, let her be there. She is a good lady, what she will do? Don't worry. She want to put a garland on Rajiv Gandhi, let her allow to be. So she put the garlands and the grenade busted. Not only she was killed, Rajiv Gandhi killed, and about 30 were killed. And this police officer lost one of his hand and part of his leg. Now she is moving in artificial limb. She has not able to work, and also some injury on the head. So suffering from regular pain. So she raised a question that who is there to defend me? What fault I have committed? So these were the few things. Who are opposing the bail, this release, they are raising all these questions, and some reporter has covered this story. And now the Congress has moved the Supreme Court, as also the India government, for review of the decisions. This is happening. In one Calcutta case, that is a very famous case. That is a case of one Dhananjay Chatterjee. He was hanged in the year 2006. Right. What was the allegation? He was a security guard in a house in a South Calcutta. So there is a school-going girl who was staying on the 4th floor. Her name was Hetal Parekh. So this was the case. One evening she was found lying killed, and it was found that she was sexually abused. So Dhananjay was picked up, and his trial continued, and he was in custody for after trial concluded within 2 years. But thereafter, the time spent in 16 years in appeal in High Court and then in Supreme Court. After 16 years, Supreme Court, in between, his death capital sentence, the capital sentence was imposed. She was directed to be hanged. And then she went to Supreme Court, and after Supreme Court upheld the order, she went for review, that she lost. Then went to the President for clemency. It was pending for 2 years. Then after 16-17 years, the Supreme Court finally said no, his clemency petition was rejected, and Supreme Court said that he should be hanged. So question arose, in our constitution, it is said that there should not be double jeopardy. So he has already spent out 16 years in jail, so almost life imprisonment. Thereafter, why she should be hanged? And in that, immediately soon thereafter, in one case, Supreme Court find out one thing, that what is called that momentary lapse. What is momentary lapse? In a similar case, the culprit put the pillow on the mouth of the victim girl and killed. The similar incident in Dhananjay Chatterjee's case. where Supreme Court said this is a case where no death sentence being imposed and other mitigating circumstances. And this year, 14th of that day was 40. I still remember because I am staying very near to the Alipur Central Jail. Now it is become converted to a museum. It is no more a jail. So that day in our area was cordoned by the police, and many people out of curiosity gathered near the jail compound to see what is going to happen. So his family is staying at remote place at Bankura, is a district, remote district. They said because we are poor, we didn't get any justice. Because now, according to the Supreme Court, this is a mitigating circumstance. From where you are coming. This is a regular thing. But now the Supreme Court is taking very liberal views that the scope of mitigating circumstances has been extended. Okay, then let us finish here today.